Hello, everyone. My name is Christian Jorgensen. I'm a legal advisor with the International Humanitarian Law Department at American Red Cross National Headquarters in Washington, D.C. Today, I have the pleasure of introducing our presenter, Ms. Maxine Hart. Maxine is a rising third-year law student at Arizona State University Sandra Day O'Connor College of Law and is currently one of our very talented and gifted legal interns at the American Red Cross. We are very fortunate to not only have her with our organization, but specifically today, where she will present on this very important topic of detention and armed conflict and its relationship to the law. So without further ado, I want to pass it over to our presenter, Ms. Maxine Hart.
Thank you, Christian, and thank you everyone who's in attendance. I'm really excited to talk about this topic that I've learned a lot about in the past month or so that I've been researching it and found that there's so much to it. So I'm excited to share that with you. We're going to be talking about the protections under IHL, International Humanitarian Law, for people who are deprived of their liberty in armed conflict. We'll start off by covering the sources of law that govern deprivation of liberty in armed conflict and the fundamental rules and the guarantees that those laws provide. We'll cover some of the important definitions that you need to know in order to determine if someone qualifies for POW status. And then we'll compare the protections for POWs with the protections that are afforded other kinds of detainees in armed conflict. And then we'll wrap up by talking about some issues that tend to come up and tend to generate some controversy in this area. So in terms of sources of law, International Humanitarian Law, or IHL, governs the deprivation of liberty in international armed conflicts and in non-international armed conflicts. In international armed conflicts, we have the Third Geneva Convention, which covers prisoners of war and has detailed provisions about their treatment. The Fourth Geneva Convention covers civilians deprived of their liberty, as well as Additional Protocol 1 and customary law. And customary law is law that isn't necessarily contained in any treaty, but arises from widespread, long-standing state practice that states engage in out of the belief that they're legally obligated to do so. And that's binding on all parties to armed conflict. In a non-international armed conflict, the law is less developed, but we have Common Article 3 of the Geneva Conventions, Additional Protocol 2, as well as customary law. And again, that's binding on all parties, including non-state armed groups. And then there's a separate body of law called international human rights law, which we won't get into as much in this presentation, but it's important to know that in general, it governs the deprivation of liberty, generally speaking. And IHL, because it's more specific during armed conflict, it's considered lex specialis, which means that it displaces certain rules of international humanitarian or international human rights law, IHRL, or it influences the way that they're interpreted and applied. So an example of that would be that under IHRL, people have a right to life. And so if you were to deprive someone of their life, that would be a violation of IHRL. But during armed conflict, IHL allows for the targeting of combatants. So targeting a combatant is not a violation of IHL. But IHL doesn't allow anyone to target civilians or POWs. So intentionally killing either of those groups of people would be a violation of both bodies of law. And the rules generally fall into these four categories of treatment, conditions, fair trial rights, and grounds and process for internment. And each of these will be more or less developed depending whether it's an IAC or a NIAC. And internment is a type of detention, which is for serious security reasons, and it's non-criminal, non-punitive, and either combatants or civilians can be interns under IHL. There are certain fundamental guarantees that apply to all people deprived of their liberty in armed conflict, whether that's an IAC or a NIAC, and regardless of any status that they qualify for. And these are found in treaties and in customary law, and they have to be applied without discrimination on the basis of race, nationality, religion, political opinion, and factors like that. The detaining power has to provide for the detainees' basic needs. So that includes food, water, clothing, accommodations. And if they're unable to do so, they have an obligation to allow humanitarian aid organizations like the ICRC to come in and provide assistance in meeting those needs. Humane treatment has to be guaranteed at all times. Certain information about the detainee has to be recorded. They must be kept away from combat zones, allowed certain correspondence with family. The religion must be respected at all times. Gender must be respected, and that generally means keeping men and women in separate quarters. Children should also be kept separately unless it's as part of a family unit. And then finally, torture is absolutely prohibited by numerous treaties and by customary law. So the first category of detainees that we'll look at are POWs. And the law recognizes, IHL recognizes that enemy armed forces are per se, by their nature, a security threat. So that allows for their automatic internment, which again is detention for security reasons. This is a picture of John McCain, who before he was a senator from Arizona, was held as a POW in the Vietnam War for 6 years. And his story, learning about his story is what initially kind of got me interested in looking into this topic. So I thought I'd kind of use his story as a reference to look back at throughout the presentation and see how some of these requirements of IHL were satisfied or in many cases violated in his case. So who qualifies for POW status under the Third Geneva Convention? There are two parts to this definition. They must be a combatant in an international armed conflict who has fallen into enemy hands. And they must comply with the principle of distinction, which means that they must distinguish themselves from the civilian population. And that has to be done during an attack or during a military operation preparatory to an attack. And if they fail to do that, to comply with distinction, they lose their right to POW status. And usually that's through a clearly visible item of clothing, like a uniform often. And then in exceptional cases, irregular forces can comply with distinction by carrying their arms openly. So mercenaries and civilians accompanying the armed forces and civilians who spontaneously take up arms in response to invading forces are two categories of civilians who do qualify for POW status without necessarily, while still being considered civilians. And then mercenaries and spies do not qualify for POW status. Spies are considered civilians and they're covered by the Fourth Convention. And a person is treated as a spy only if they're caught while engaging in espionage. So previous acts of espionage before capture won't deprive a person of their right to POW status. And then mercenaries, there's a way that this word is used colloquially, but under IHL, it has a very narrow definition and it's got 6 parts and it's really hard to satisfy and practically almost is never satisfied. So that usually won't include actors like private security contractors. So who is a combatant? It's going to be all members of the armed forces of the party to the conflict except medical and religious personnel. So then we need to know who qualifies as the armed forces of a party to the conflict. And often it will be regular armed forces, which generally they'll be in uniform and they'll have extensive regulations and codes of conduct, things like that. So what you think of when you think of the armed forces usually. But you can also have irregular armed forces and they have to satisfy some additional conditions. And so under the Third Geneva Convention, there are these 4 elements that have to be satisfied. And so that includes a requirement that as a group, the irregular armed forces comply with the principle of distinction. So if as a group they don't, then each member of the group loses their right to POW status. And then there's additional protocol 1. And under that standard, the distinction requirement seems to be a little bit relaxed, and that's more controversial. The US rejects this provision and is not a signatory to additional protocol 1, but it's a similar requirements where irregular armed forces have to meet additional criteria. Their members aren't automatically eligible for POW status the way that members of the regular armed forces are. And whatever kind of armed forces we're talking about, POW status requires that the individual also respect and comply with the principle of distinction from the civilian population. And then finally, it's not necessary that the detaining power recognize the legitimacy of the government that is at the head of the armed forces that we're talking about. So if there's a de facto government and the facts on the ground are that it does control the armed forces, then that's enough to satisfy this armed forces definition. So this is the fighter plane, the type of fighter plane that McKean would have been flying at the time that he was shot down and then subsequently captured. So he was a member of the Navy. He was a Navy pilot. And so that qualifies as regular armed forces. And because we can tell that this is a military plane, it's not trying to be disguised as a civilian passenger plane or anything like that. He qualifies for POW status because he also was engaged in an attack at the time on a military target in Hanoi when he was shot down. So he qualifies for POW status. So a really important part of the application of POW protections is that POWs have what's called combatants privilege, which means that they have the right to participate in hostilities. And so they can't be punished for acts of violence that are otherwise lawful under IHL. So for their mere direct participation in hostilities. They can, however, be punished for war crimes. As I said, the purpose of detention is not punishment. It's to prevent them leaving and rejoining the enemy forces and participating in hostilities again. So because of that, because they're a per se security threat and the purpose is to prevent that threat from materializing, there's no particular procedure required for their internment, and there are no individualized grounds required. In cases of doubt, if someone is captured having committed a belligerent act, and there's some doubt as to whether they qualify for POW status, the law requires that there's a presumption that they do qualify for POW status and that they benefit from the protections of the Third Geneva Convention until the determination whether they do in fact qualify is made by a competent tribunal. And that can be either civilian or military. And the procedures that the tribunal has to follow aren't contained in international humanitarian law. Those will be determined by domestic law. And that determination, again, has to be made on an individual basis to determine if this individual person qualifies for POW status or not. And then the status applies from the moment of capture until final release and repatriation, even if they're convicted of war crimes. So the treatment of POWs is laid out in quite a bit of detail in the Third Geneva Convention. I was kind of surprised when I was looking into this because I figured, it would be don't torture them and certain prohibitions, but it's actually very detailed affirmative obligations of everything from, like I said, the fundamental things like food and accommodations, but also labor and recreation, and certain communications that have to be allowed with the outside world. And so one example of this are capture cards, which when a POW is captured, as soon as they are captured, or at least within a week, they have to be allowed to fill out these cards, and those are sent to their families and to their state of origin to let them know hey, I've been captured and this is my location, my condition of health, and just sort of the basic things like that. John McCain would be an example of, I think, when this was not followed, because his family didn't really know what had happened when his plane went down, and it didn't look like there had been any survivors, and they didn't find out that he had actually been captured until a journalist was allowed in to interview him. And it wasn't like the ICRC going in to do a check. It was more that the detaining power let this journalist in who they thought would be sympathetic to the cause. And so that's how his family found out that he was being held as a prisoner of war. And then, like I just mentioned, some monitoring is required to be allowed by either the ICRC or protecting power. And a protecting power would be a neutral state that's not part of the armed conflict. And either of those under international law has the duty to oversee the implementation of IHL, excuse me. And that includes being allowed to visit POWs anytime and any place that they're held, and to interview them. And generally, like I said, the purpose of this internment isn't punishment. So the conditions should be just enough to prevent people from leaving, but they shouldn't be prison-like. So they shouldn't be held in a normal penitentiary or in close confinement. And again, in John McCain's case, that certainly a lot of rules of IHL were violated in terms of his conditions. He was tortured brutally and required medical care that he didn't receive. It was dark and damp and not conducive to health. And he was held sometimes for months on end in solitary confinement. So there were definitely some violations there. POWs have to be repatriated without delay after the cessation of hostilities. And there's an obligation to repatriate them sooner if they are severely sick or wounded. That would be the case, again, also in McCain's case, because he had broken both of his arms and one of his legs when his plane was shot down. And his condition got a lot worse because he was held in these horrible conditions and didn't have adequate medical care. And so he was really in a very serious condition. And they did at one point offer to repatriate him early. But he felt like that was because his father was an important military figure and he was getting preferential treatment. And he also felt that it was contrary to the military code of conduct that he was following, which said that POWs should be released in the order that they were captured. So the first to be captured should be the first to be released, and that would have put him out of order. And so he refused to be repatriated when he was offered that. And he stayed in, I believe, for years longer after that. And his treatment kind of really got a lot worse after he refused to be repatriated, which itself is a violation of IHL. Of course, because torture is prohibited, but also because detainees shouldn't be punished for refusing to be repatriated. And then finally, this is a picture of him when he was eventually repatriated, along with about 100 other American POWs that were held with him. So the second category is covered by the Fourth Geneva Convention, which is relative to the protection of civilians in times of war. It defines protected persons broadly as those who at a given moment and in any manner whatsoever find themselves, in case of a conflict or occupation, in the hands of a party to the conflict or occupying power of which they are not nationals. It expressly does not include anyone who's protected by the Third Geneva Convention, so anyone who qualifies for POW status. And this nationality requirement at the end also means that anyone who's a national of a neutral state or a national of a co-belligerent state does not qualify as a protected person. But assuming that the nationality requirements are met, generally it's defined as people in the power of a party to the conflict other than POWs. Internment of civilians is allowed only for serious security reasons. And the standard is a little bit different depending on whether we're in the detaining power's own territory where the person is captured. And in that case, the internment must be absolutely necessary for the detaining power's security. In occupied territory, the standard is imperative reasons of security, which is a little bit higher, just to sort of emphasize that internment should be an exceptional measure. This determination has to be made on an individual basis, and every 6 months there should be a review of whether the security justification that justified the internment in the first place still exists. The provisions regarding treatment and conditions of internment for civilians in the 4th Geneva Convention are very similar to those for POWs in the 3rd Geneva Convention. But civilians may be punished for their direct participation in hostilities because they don't have combatants privilege. So they don't have the right to participate in hostilities. Their release has to happen as soon as the reasons justifying internment no longer exist, which is at the latest as soon as possible after the end of active hostilities. And then additional Protocol 1, Article 75 contains certain fundamental guarantees that act as like a sort of floor of protection to make sure that no one is left unprotected if they're not covered by either one of the Geneva Conventions or the additional protocols. That includes the fundamental guarantees include humane treatment, the prohibition of torture, the prohibition of the arbitrary deprivation of liberty, and those fundamental guarantees that we've seen. Not all states are party to additional Protocol 1, like the US is not, but this article in particular reflects customary law, so its provisions are binding on all parties. So an issue of status that sometimes comes up and is pretty controversial is unlawful or unprivileged combatants, which is when someone who doesn't meet the requirements for combatant status, they're not a member of the armed forces, and they don't comply with, or they don't comply with the principle of distinction, and yet they directly participate in hostility. So the question is, this term unlawful or unprivileged combatants isn't used in IHL treaties. So it's clear that they can be prosecuted for their direct participation in hostilities because they don't have combatants privilege. But the question that's controversial is whether they're still covered by the 4th Geneva Convention on the protection of civilians in armed conflict. And there are two sort of main viewpoints on this, and we'll take a look at what those viewpoints are, the arguments for each of them, and the implications of each view on how to treat unlawful combatants. So under one view, if someone has combatants privilege by being a member of the armed forces and complying with distinction, of course, they qualify as a POW and they're protected under the 3rd Convention. If they don't have combatants privilege because they don't meet one of those two criteria, then the question becomes whether they participated directly in hostilities. If they didn't, then they are just a peaceful civilian who's being detained, then they're a protected person under the 4th Convention. If they did, and this is the controversial part, then under this view, they're an unlawful combatant who isn't covered by either of the conventions and instead is only covered by the fundamental guarantees in Additional Protocol 1, Article 75. The argument in favor of this is that we shouldn't privilege those who don't comply with the conditions for a status compared to those who do comply with the conditions for a status under international humanitarian law. And also the 4th Convention, the title of the 4th Convention refers to civilians, and we generally tend to think of civilians as peaceful. The implications of this view are that lawful combatants or unlawful combatants like lawful combatants can be targeted for attack and can be detained without judicial decision. And unlike lawful combatants, they are not immune for prosecution for acts of violence that are otherwise lawful under IHL. So they can be punished for mere direct participation in hostilities. And then under the other view, which is the ICRC view, you ask whether they have combatants privilege. And of course, if they do, they are POWs and they're protected under the Third Convention. If they don't have combatants privilege, then they are a protected person under the Fourth Convention, assuming that they meet the nationality requirements. But generally, the view is that IHL creates a binary and exclusive classification. So everyone is either a combatant covered under the Third Convention or a protected person covered under the Fourth Convention. And the arguments for this are partly textual, because the definition of protected persons under the Fourth Convention says all people in the power of a party to the conflict, except those covered by the Third Convention. So the implication of that is that if you're not covered by the Third Convention, you're a member of all of the other people who are covered by the Fourth Convention. And there's also policy arguments for that, because unlawful combatants can be harder than lawful combatants to categorically identify. So it's more likely that an individual determination about their status will be required, as is required under the Fourth Convention. And that under the other approach that we saw, the first approach, it kind of creates a loophole that states could take advantage of to deprive people of the protections that the Geneva Conventions were designed to guarantee. And then finally, also, there's an argument that considering unlawful combatants to be protected persons under the Fourth Convention really doesn't undermine other important concerns that states might have. Because, if you're considering them to be civilians, you can still target civilians during the time that they are directly participating in hostilities. You can still intern civilians for security reasons, and someone participating in hostilities would certainly be a security concern that would justify interning a civilian. You can prosecute them for direct participation in hostilities because they're civilians and they don't have the right under IHL to participate. And of course, you can prosecute them for war crimes, which you can also prosecute POWs for war crimes. And then under either approach, you can interrogate the detainee, but you can't coerce them into giving answers or torture them if they don't give the answers that you're asking for. So this is an example of how a court would apply this area of IHL. In this case, out of the International Criminal Tribunal for the former Yugoslavia in 2017, the case dealt with armed conflict that happened in the wake of the dissolution of the former Yugoslavia. And the parties were the HBO, or the Croatian Defense Council, and Bosnia and Herzegovina on the other side, which was predominantly Muslim. And so the HBO detained its own members of its own armed forces who were Muslim because it suspected them of having, because they were Muslim, of having an allegiance to the enemy. And so the issue in that case was the status of those Muslim HBO detainees detained by their own, armed forces that they were a part of. And so the court first considered whether they qualified as POWs, and it decided that they didn't because it was their own armed forces, and that doesn't meet the definition of being in the power of the enemy under the Third Convention. So then it looked at whether they count as protected persons and would be covered under the Fourth Convention. And the court said that even though the Fourth Convention mostly deals with civilians that we think of in the sense of being peaceful, and not being members of the armed forces, the actual definition of protected persons in the convention is broad enough that it includes armed forces if they don't meet the strict requirements of the Third Convention. So this is basically adopting the ICRC view of that we saw earlier, where it's binary, you're either covered by one or the other of the Third or Fourth Convention. And additionally, the court said that the nationality requirement in the Fourth Convention should be read broadly, to include allegiance or perceived allegiance. So because these men were detained because they were Muslim and perceived to have an allegiance to the enemy, that was enough to satisfy the nationality requirement and to be in the power of a party of which they were not nationals. And so according to that logic, since they weren't protected by the Third Convention, they were protected by the Fourth Convention, and they met the nationality requirements. And the court also went on to say that that outcome is really supported by policy because every person in enemy hands must have some status under international law. There's no intermediate status. Nobody in enemy hands can be outside the law. So again, that's sort of the loophole argument, that there shouldn't be a way to, people shouldn't fall through the cracks of protection. So this table summarizes kind of some things we've already covered, which are that the fundamental guarantees, being fundamental, apply to all categories of detainees. The grounds for detention vary depending on what the status of the detainee is. So the minimum is that it can't be arbitrary. There have to be some legal basis, grounds, procedural guarantees required for internment. For the internment of civilians, again, it's absolute necessity or imperative security reasons. That's an individualized finding. For prisoners of war, it's automatic because they are per se security threat. And there must be a competent tribunal if in doubt as to whether they qualify for that status. Repatriation and release, the minimum for anyone not covered by the Third or Fourth Convention is that they must be released with a minimum delay as soon as the circumstances justifying the deprivation cease to exist. It's very similar for civilians when the security threat doesn't exist anymore, and there needs to be a review to decide whether that security threat exists every 6 months. And again, for POWs, it's at the end of active hostilities. All three categories can be prosecuted for any war crimes that they commit, but it's only POWs who can't be punished for merely directly participating in hostilities in a way that is otherwise, or that is lawful under IHL. So in non-international armed conflicts, these are the most common form of conflict today, but the law is a lot less developed in NIACs than it is in international armed conflict in IACs. We have Common Article 3 of the Geneva Conventions, the second additional protocol, and customary law. As I said, that's binding on state and non-state groups. And like I mentioned earlier, the prohibition of arbitrary detention, arbitrary deprivation of liberty, is customary law. It's one of the fundamental guarantees. So that applies in this context too. But so there needs to be a legal basis and grounds and procedures for detention. But Common Article 3 and Additional Protocol 2 are silent on what these grounds are, the legal basis on which you can intern someone. And so the question is, internment happens commonly in NIACs, and where do the grounds, the basis, the power to intern come from? And there are different views on this. So one view is that IHL can't provide an implicit basis for internment. It needs to be something explicit, the way that it is in the Fourth Convention. So saying that if someone is if it's absolutely necessary for security or imperative security reasons, some kind of explicit standard like that. Some people say that customary and treaty IHL give an inherent power of internment in NIACs. And that's because they don't, internment is common and the text of these treaties doesn't prohibit it. It's even mentioned in some occasions in those treaties. The ICRC position is sort of a middle position where there is an inherent power of internment, but the grounds and the basis, the procedures for that internment need to be found in some other body of law that lays them out more specifically. So in a traditional NIAC, which is when there's a state party that's fighting against a non-state armed group in its own territory, The legal basis and grounds and procedures will be found in the domestic law of the host state. In a NIAC with an extraterritorial element, it's a little bit more complicated. And in that situation, it would be where there's a traditional NIAC, so a state and a non-state group, and then either international forces or another outside state come in and join the side of the state in fighting the non-state armed group. So they have the host state's consent to be there. So it's still a NIAC because it's not one state using force against another. And so the grounds and procedure, the basis of internment could be found in that case, either in the domestic law of the host state or in an agreement between the host state and the assisting state, or in rare circumstances, exceptional circumstances, in the domestic legislation of the assisting state. And so there's some debate about whether we need more defined IHL obligations in NIACs. And it's really an issue of balancing protecting detainees with not making the requirements so extensive that you're discouraging detention, especially by non-state groups, because in reality, the alternative to detention often is other forms of violence, killing someone. So detention obviously is preferable to that. So it's about finding that balance. And the ICRC guidelines or has issued guidelines that recommends that the standard in NIACs, the minimum standard, be imperative reasons of security. And it's also put forward some procedural mechanisms for reviewing and challenging whether an internment is lawful. And then lastly, this issue of terrorism comes up sometimes, and it's not a legal term of art used in any IHL treaties. Groups that are labeled as terrorists are subject to the same rules and obligations as any other party to armed conflict. IHL doesn't determine the legitimacy of belligerent's cause, and it applies whether or not the first resort to force was lawful. And there's some issues with labeling acts as terrorist if they are not actually violations of IHL. Because first of all, that can create conflicting obligations for states, because if something's called terrorist, it sort of implies that there is an obligation to prosecute that act. But if it's lawful under IHL, obviously there isn't. It could discourage compliance by non-state armed groups because they could be fully complying with IHL and yet still be labeled terrorists. And, that's a risk that they'll just sort of give up even on complying with IHL. And it can be an obstacle, calling a group of terrorist organization can be an obstacle to amnesty, peace negotiations, and reconciliation, which can further the humanitarian aims of IHL. And then there are laws often that criminalize material support or material aid to organizations that are designated as terrorist, and that could have a chilling effect or criminalize humanitarian action. It threatens the principle of neutrality in humanitarian work, and really the problem with that is that it works to the detriment of people who are civilians and other people who are in the power of the party that is a party to the armed conflict that's being labeled terrorist. So it's hurting the people that IHL is meant to help, is kind of the concern. And with that, I'll wrap up with any questions that anyone has.
Hi, Maxine. Can you hear me? Sorry about that.
That's okay. Yeah, I can hear you.
All right, cool. Well, thank you so much for your interesting presentation. I know I found it very informative, and I've learned a lot from you. I do have a couple quick questions, if you don't mind. I know earlier you mentioned the ICRC, and given that some of us in the audience, including myself, are work for or volunteer with the Red Cross or Red Crescent movement and are a part of that Red Cross family. I guess my question is, what are some of the obligations under the law or maybe the duties of the ICRC with regards to POWs? I know you mentioned some, but I was hoping maybe you could do a recap on that.
Yeah. So, of course, the ICRC has to be allowed to visit POWs, like I mentioned. And there's the possibility that while they're there, they might witness violations of IHL that amount to war crimes. And under IHL, the ICRC can't be compelled to cooperate with authorities in prosecuting violations of IHL. So they have this special privilege under the law that comes from the ICC rules of procedure and evidence that's recognized under customary law, and that comes also from their agreements with host states where they operate. And the reason for this privilege, for them not having to provide evidence or to testify to any violations that they've seen or heard about, is not that they don't want justice for violations of IHL, but it's that if they could be compelled to provide that evidence or information, then parties to conflict might be less willing to allow them to have access in the first place. And so because the aim is really to help people who are suffering, who are in the power of parties to the conflict, they need to be able to assure that confidentiality to the detaining power. But that also doesn't mean that they don't have the ability to provide evidence to authorities. If they determine that in a particular case, the circumstances are, there's such an exceptional need for evidence that the ICRC has, and, that maybe that outweighs the harm to whatever access they have to POWs. That determination needs to be up to the ICRC and not up to an authority, a court, compelling them to provide evidence.
Yeah, very interesting. They don't want any obstacles getting in their way from doing the important work that they undoubtedly do. So the next question I have kind of goes with that enforcement. I know you just mentioned the courts, and that got me thinking, from your research preparing this presentation for all of us, are there any notable international criminal prosecutions with regards to the treatment, or rather mistreatment of POWs, or is this more commonly based, or did you find in domestic and military courts? I was just wondering if you could touch on that enforcement aspects as you just mentioned in your ICRC answer.
Yeah, so the ICTY case that I touched on briefly, the 6 people who were accused of war crimes were convicted, and those included mistreatment of detainees. And in that case, the detainees weren't POWs because, as we saw, they didn't qualify. But it's more common for these issues to end up in domestic courts. And so those can be civilian courts or military courts. And an example from the US would be the conviction of 11 US soldiers for the mistreatment of detainees at Abu Ghraib. And their sentences, that was in military courts, and their sentences included prison time, but also fines, loss of their pay, demotions, disciplinary things like that, bad conduct and dishonorable discharge. So it's more common that it'll be handled in the domestic setting. You're muted, Christian.
Sorry about that. Yeah, thank you. We do have one question in the chat right now. The question is, so if we're in an international armed conflict setting, and the combatants on one side resort to some crime against the civilian population, and more or less if the civilians being harmed take up weapons in defense, the first question is, from your research, if you found any, do they lose civilian status if they're defending themselves? And then the second part of the question is, more touches on your presentation, if they're detained, are they POWs? So I guess I'll summarize this question very briefly to the second part of the question. When do civilians receive POW status? So, for example, if civilians are like a war correspondent, for example, or civilians accompanying the armed forces, as the law labels them, do those people get POW status rather than just internment?
Yeah, so those there are two special categories of civilians who do qualify for POW status, and that's exactly the situation where armed forces come in and the civilians take up arms, and then they do qualify for POW status. And then the other, like you said, would be civilians accompanying the armed forces. But in the case of civilians taking up arms, even though they're civilians, they are directly participating in hostilities, so they can be targeted during the time that they're directly participating in hostilities, even though, there's civilians taking up arms.
Yeah, and then I'll add to that, as far as civilians directly participating in hostilities, their participation for that classification has to be tailored. The reason behind their participation has to be tailored to the military conflict at hand. Civilians are very much allowed to defend their property, etc., which doesn't necessarily mean that they're GPHing. So we always have to look behind the motivation between why civilians are taking part when we start doing providing labels to those groups of people. Are there any other questions for our speaker today? All right, well, I think that's it. Maxine, I want to thank you for spending your afternoon with us, or your morning out there in Arizona. And I want to thank you all for joining us. We will be posting a recording of this to our website, www.rulesofwar.org/webinars. This will be under our IHL Primers session. Thank you again, everyone, for joining us. And if you want to learn more about our department, our work in IHL, please contact your local Red Cross office. Thank you.